This is in the Circuit Court of the 13th Judicial Circuit in Fort Hillsborough County, State of Florida, General Civil Division. This is the estate of Lisa McPherson by and through the personal representative Del Liebrick as plaintiff versus Church of Scientology Flag Service Organization, Inc., Janice Johnson, Elaine Kardazinski, and David Houghton as defendants. The case number is 97-1235, Division H. This is the trial deposition of Robert Vaughn Young. Today is January 21st, 2000. It is 11:09 in the morning. At this time, I'll ask the attorneys to introduce themselves.
Ken Dandar for the estate of Lisa McPherson, Dr. Michael Garko, and Jesse Prince on my left.
Bob Polai for David Houghton.
Doug Titus representing defendant Elaine Kardazinski.
Ron Haynes on behalf of Janice Johnson.
And Sandy Weinberg for the Church of Scientology, Flag Service Organization. With me is Laura Cartwright and Mike Render, as well as Michael Hertzberg.
Okay, please swear in the witness.
Would you raise your right hand, please? Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Ken, before we begin, I want to state an objection for the record. We object to going forward with this deposition at this time for a number of reasons. We adopt the reasons that were stated by Mr. Titus earlier. We object to this being characterized as an emergency. We were not provided with the discovery that we were entitled to. We were provided with 9 inches of documents yesterday and a 125-page filing, so we couldn't possibly be prepared. We by accident got a copy of an affidavit that Mr. Young refused to testify about that he'd already done a month ago. We got it by accident because it happened to be filed a day ago in California, which is specifically apparently on point to one of the things he was testifying about. So we object on that ground. We also object to going forward with this deposition under Rule 702 of the Florida Evidence Code and the Daubert, D-A-U-B-E-R-T, and Kumho, K-U-M-H-O, and Fry cases with regard to the standard that applies concerning expert testimony. We believe that it is very clear from the testimony, the deposition testimony of Mr. Young, that he could never be qualified as an expert under those standards, and that the under the law, and that the opinions that he said that he's going to be asked to give do not fall within any of the standard as opinions that would ever be accepted as expert opinions. That his opinion his opinion would be unreliable, that it would not assist the finder of fact in determining any issue in the case, and that he could never be qualified as an expert in whatever it was that he's trying to be qualified in, the religiosity of Scientology, because of his status as an apostate, because of his paid status as an anti-Scientology witness over the past 10 years, and because of his lack of education, experience, knowledge, or skill. We also want to make it clear that pursuant to the rules that all objections except as to the form of the question are reserved, and so that today we will be making appropriate objections as to form, but not objections as to anything else except the Daubert type objection that I just made. Is that acceptable?
It's acceptable, and none of you have to repeat those objections on the 702 and Daubert.
Okay.
And I am thankful that you will all only object to form, and there will not be any speaking objections. Correct?
Well, I believe in the First Amendment, so I'm not going to limit my ability to speak. but I wanted to make it clear that all objections as to form, except as to form, are reserved.
That's what the rules are, and the rules also provide you have no First Amendment rights to make speaking objections during a trial deposition.
Well, you know,
let's not argue that point. Let's go on. Okay.
Mr. Gander,
You started at 10:08 on your objection. It's now 10:13.
Okay, well, let me take 2 minutes then to just, on behalf of Alen Kartazinski, for this trial record, because this is a trial deposition, I want to state for the record, first of all, that I adopt the statement and objections that Mr. Weinberg made. I want to make for Mr. Kartazinski an objection to this proceeding, objection to this trial testimony going forward under the circumstances as we discussed with the court yesterday. I want to make
some time on this again.
Because I want to make sure it's clear on this record at the trial deposition that Mr. Kartazinski is not waiving anything. He's not waiving his right to continue.
So noted for all of you. I said that. It's all noted. You do not waive any objections.
Or the right to proceed with discovery deposition.
Absolutely.
After we finish this, and we're retaining all rights.
Right, and that goes for everybody, all parties.
Thank you. I'm going to add one thing. You may not like it, but I'm going to. Since we just concluded the discovery deposition under your emergency schedule, we have not had the opportunity to file an appropriate motion to preclude this deposition from going forward based upon our evidentiary objections that Mr. Weinberg has set forth, and that would have been our intent but for this emergency schedule. Therefore, we're reserving all those objections. Likewise, as I believe that what we're about to do is a waste of the time of the attorneys involved in this case based upon my understanding of the opinions that you have provided that you will be offering.
Mr. Young, please state your full name.
Robert Vaughn Young.
And how old are you?
63. Well, 63 in April.
Okay. We are proceeding to take your trial testimony at this time much earlier than we would have normally done, i.e. would have been in a trial. Because of your...
Objection. Now, this should not be on the record. None of this. This is just a statement by you. The circumstances of why we're going forward today...
Is this a form question objection?
No,
we just had an agreement. Did we not?
Look, Ken, it is absolutely inappropriate to get into anything that has to do with Mr. Young's health. Okay, you're going forward. You wouldn't be able to ask those questions at trial, and you shouldn't be able to ask those questions now. Let's just go forward with this deposition, not make statements.
Do not do that again. I will get Judge Moody on the phone. You will not dictate how I conduct a direct examination. Do you understand?
Don't yell at me.
You're yelling at me.
No, I'm not.
Now, don't do it again.
Unfortunately, we have video here because I'm not yelling at you. What you're doing is inappropriate.